Tamil Nadu Governor RN Ravi is back in the thick of a controversy. The Supreme Court has raised uncomfortable questions about the governor indefinitely holding up bills passed by the Assembly. Has the Raj Bhavan indeed been converted into a Rajniti Bhavan or political Bhavan? Vanakkam, this is T. Suresh Kumar. Thank you for joining me in this episode of the Hindu Focus Tamil Nadu. Today, let's examine how a case filed by Tamil Nadu in the Supreme Court has exposed certain questionable actions taken by the governor in dealing with crucial bills and files. It all began with the government approaching the Supreme Court accusing the governor of almost causing a constitutional deadlock by not taking action on bills and files that are sent to him. On November 10th, the Supreme Court expressed serious concern over this action of the governor and issued notice to the Home Ministry to respond. And this is when things took a very curious turn. In a matter of 3 days, the Tamil Nadu governor returned 10 bills to the Assembly with merely stating that I withhold assent. He did not mention any reasons for that. This was unprecedented, and in an equally unprecedented reaction, the Tamil Nadu government placed all these 10 bills in a special session of the Assembly on November 18th and readopted them and sent them back to the governor. The Supreme Court has orally observed on Monday that perhaps now the governor may have no option but to accept and grant assent to these bills. This case, in fact, would provide a crucial platform to settle a critical constitutional question on whether a bill for which assent is withheld by the governor can indeed be considered as dead as claimed by Mr. Ravi some months ago, and also whether a bill for which assent has been withheld by the governor could be readopted by the Assembly as in the case of bills that are returned for reconsideration. Let's leave aside those issues for the courts to answer. But this episode has also exposed Mr. Ravi to the charge that he is functioning more as a political rival to an elected government rather than functioning as a constitutional authority. Why? Because in May this year, the governor was on record claiming that no bills adopted by the Assembly in 2022 were pending with him. He in fact said that he had withheld assent to 8 of these bills and gone on to explain that these 8 bills pertain to state universities, essentially amendments to statutes of state universities seeking to vest control in the government for selecting vice chancellors to universities, taking away these powers from the governor. But a note that has been submitted in the Supreme Court by the Home Ministry on Monday states that these bills were actually returned by the governor only on November 13th, that is 3 days after the Supreme Court expressed displeasure over the governor's conduct. So, if the governor indeed in May had withheld assent, why were there no file notings about this? Why was his decision not communicated to the government officially? And why is it that now it has been stated that these bills were actually held back by the governor for assent on November 13th? Is it because the matter is now in the Supreme Court? Now let's see another action of the governor. The note submitted to the Supreme Court also reveals a political action by the governor. The governor has now on November 13th granted sanction to prosecute 2 former ministers of the AIADMK in the multi-crore Gutka scam. Now, people are questioning if the governor's action is linked to the fact that the AIADMK recently snapped ties with the BJP at the centre. Why is this question being raised? Because in July this year, when Tamil Nadu Law Minister wrote to the Raj Bhavan urging the governor to clear files in which the government had sought sanction to prosecute these 2 ministers, Vijay Bhaskar and Ramana, the Raj Bhavan had responded saying these files were under consideration. It is important to note that in July, the AIADMK was very much in the NDA led by the BJP. And it was only in late September that the party exited the NDA. Therefore, now it's being questioned why the governor is granting the sanction now. Is it merely because the matter is in the Supreme Court, or is it also because of these political reasons? In the same case, in July, The Raj Bhavan had expressly stated in a press release that it had not received any file from the Tamil Nadu government related to sanction for prosecuting former Transport Minister M.R. Vijayabhaskar. But in this note submitted to the Supreme Court, they acknowledged that indeed a file was received in May in this connection. So, was the Raj Bhavan not telling the truth earlier? That is the key question. While of course governors do take a lot of time in examining bills, it may not always be due to constitutional or professional reasons. Because in these cases, some of these bills were pending in the Raj Bhavan for almost 4 years and they were passed during the erstwhile ADMK government. And some of the bills were pending for close to 1 year. In the past, there have been accusations that the Raj Bhavan usually functions politically when it comes to clearing bills. A classic example of this is the 10.5% internal reservation that was given to the Vanyakula Kshatriyas. The bill for this was passed on the last day of the assembly in February, and within 3 hours, the governor had granted assent. At that point, Banwarilal Purohit was the governor. So the big question is, can Raj Bhavan resort to such tatkal clearances? Ideally, they should be exercising their role as constitutional authorities and not acting out of political considerations. I shall meet you in another video. Until then, this is D. Suresh Kumar signing off. Thank you.